Donald Trump has already been found guilty in a court of law. He faces up to 4 years in prison for falsifying business records as part of a criminal hush money scheme to influence the outcome of the 2016 election. Now, for those crimes, Trump was originally scheduled to be sentenced next week. That was until the Supreme Court granted Trump immunity from virtually anything that could be considered an official act. As a result, next week's sentencing has been postponed to September 18th, so that the judge in this case, Judge Juan Merchan, has time to consider an argument that Trump's defense lawyers have used in multiple criminal cases, that his guilty verdict should be thrown out entirely. Joining me now to discuss the likelihood of that actually happening is Christy Greenberg, a former federal prosecutor. Christy, I am intrigued by this. I will say, I have long wondered what the impact of the Supreme Court decision might be potentially on the New York hush money case. And I wonder what parts of that conviction are potentially most imperiled in your eyes.
So I don't think the conviction is imperiled. That's the good news. Look, the charged conduct itself, directing your personal lawyer to make hush money payments to a porn star and then reimbursing him and covering it up, none of that's official conduct. So it doesn't matter that he signed the checks to Michael Cohen from the White House. They were from his personal account to his personal attorney, unofficial conduct. The real question then becomes whether any evidence of Donald Trump's official acts was used to prove these unofficial acts, because the Supreme Court says now that you can't use any of that. So I spent a good amount of time reviewing the evidence that Trump's lawyers have now cited as saying that it's official act evidence that couldn't have been used and was improperly admitted at trial. And then I looked at the rest of the trial record. And essentially what I found is that even if you take the pieces of evidence that Trump's attorneys say shouldn't have been admitted, even if you take that out, it was largely cumulative of other evidence that was already in that trial record that was proving Trump's guilt. So the bottom line is the evidence of Trump's guilt is overwhelming, even without that evidence that Trump's team is citing. And so I don't think any of that evidence that they're concerned about is make or break evidence that would have led a jury to acquit. So I think this verdict will still be upheld. I think it will still be intact. This is at least one case where I think people can breathe a sigh of relief, at least for now.
Yeah, and it sounds like, so some of the evidence they're trying to get out of this is some of those Oval Office conversations, presumably between Pecker, Trump, and Cohen. You sound pretty bullish on the integrity of the conviction standing up. It also sounds like they tackled the immunity thing a while ago. They've already gone down this lane, and they've effectively waived their right for immunity already, have they not?
So they definitely waived their right to challenge the charged conduct. That's for sure. The judge already ruled on that and said, this is untimely. You had the opportunity to raise this a while ago. Same thing with the evidence. But again, now we have the Supreme Court opinion saying that you can't use any evidence of official acts to prove the unofficial acts. That's new law. That was not the law that the DA's office cited. That wasn't the law even that the judge seemingly relied on in letting that in. So that's new, and they have to deal with that. But as you said, testimony, conversations just because they happened in the Oval Office, that doesn't make them official. I think something like a conversation with Hope Hicks, who was then the White House communications director, when they're having a conversation, for example, about how the Stormy Daniels testimony, how that story would play in 2018, arguably could be official conduct, that conversation under this opinion. But again, there were many other conversations from Pecker's testimony and from Michael Cohen's testimony, both before and after the election, about the fact that Donald Trump didn't want these women's stories to come out to negatively affect the campaign. And his communications, even when he was president, with private parties, that's not plausible to be official conduct. So again, I think we're on solid footing with a lot of this evidence.
I do have to ask, as we talk about what the impact of the court's decision on immunity is in these other federal criminal cases, what you think happens on the January 6th case, because it's now up to, the ball is in Judge Chutkan's court, right? And she can have these evidentiary hearings. And I wonder if you think we should be expecting sort of mini trials, if you will, around the evidence that can be used in this. Is the public going to get some sort of smaller, bite-sized version of a trial in the form of one of these hearings? Or is that overestimating the sort of information we're actually going to get made public?
So bring on the mini trials. I think there's no reason here for Jack Smith to really hold anything back. This is for all the marbles, right? Like you have most of the indictment that is at least still in play. And so he's going to have to bring out his witnesses, his documents to be able to prove that these are, in fact, either official acts, but you rebut the presumption of immunity, or that they're unofficial acts. And so I think we should expect to see a lot of his evidence brought forth. And those hearings should happen before the election. There's no reason to delay. You'll expect that there's some briefing over the summer, but come fall, we should be seeing these hearings. And there's a lot that's still at play here. Donald Trump's attempts to pressure Mike Pence to count these, to not count the legitimate elector votes. Yes, there's presumptive immunity under the Supreme Court opinion for those, but that can be rebutted. And the Supreme Court itself said the vice president was not acting in his executive branch function when he was presiding over the Senate, and that Donald Trump has no authority whatsoever with respect to counting those electoral votes. So expect testimony from Mike Pence and others to that effect. Even Supreme Court Justice Barrett said, as to the slates of fake electors, that's private conduct. So again, I think we're going to hear from a lot of these state officials that Donald Trump was trying to pressure, a lot of private actors, people that he was trying to get to interfere with those state processes, which the president has no authority whatsoever to tell the states how to count their electors. So I think that fake elector scheme will still be in play, and we'll get a lot of evidence as to that. And then there's that last bucket about everything connected and leading up to January 6th. And there, we're going to hear more about how these tweets came about, how the communications came about, but it would be quite incredible to think that "Be There, Will Be Wild" is an official act of a president. The Supreme Court said, look, presumptively, a lot of communications are going to be official acts, but there are communications that fall in the bucket of candidate Trump. And I think a lot of his address, "Fight Back to Take Our Country Back," sending the crowd to January 6th, it's once the evidence comes in about what was going on surrounding those contacts, it's really hard to see them as anything but candidate Trump and not President Trump.
Be there will be wild, not in the annals of presidential speech. Christy Greenberg, it's always great to get your expertise on this. Thank you so much for dropping some wisdom tonight. Really appreciate it.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.